Aibo. What I'll do is I'll just... Good morning, everybody. My name is Asghar Bawa. I'm the committee secretary. The chairperson has been deployed elsewhere by the party and has nominated Honorable Nodada to chair the session. In terms of the NCOP rules, I would just like to get a proposer and a seconder so we can make it official. Can I have a proposer and a seconder for chairperson's nomination? Mam Dlamini is proposing.
Good morning, colleagues. I move to nominate Honorable Nodada to act as the chair of this committee today in the absence of the chairperson.
You said
Good morning, Acting Chair, all members. I formally propose, support the proposal as tabled by Honorable Dlamini. Thank you.
thank you very much. I appreciate it. Mam Nodada, the chair is yours. Thank you.
Thank you, Mr. Bauer. Good morning, everybody. Good morning, honorable members. Good morning, officials from small-scale fisheries and our support staff. I was holding my fingers because I wasn't sure whether I would be voted out of this seat I already occupied. But thanks to the honorable members that they accepted me as the chair for the day. I don't think we need to waste much time in a lot of things, just to welcome everybody to the meeting and declare the meeting open. And I would then ask the secretary to flout the agenda so that we can adopt it formally. Thank you.
Thank you, Chairperson. Unfortunately, my laptop doesn't work with the system in here. I'll just mention it. We're receiving a briefing today from Legal Resource Centers and Masifundise, as well as Mr. ESTA, on the small-scale fisheries sector. And then we'll be adopting the 2 sets of minutes after that. That is the agenda for the day. Thank you.
Thank you, Mr. Bauer. Anyway, the agenda was sent to us all. I should think everyone would recall what you just said. May I have any mover for the adoption of the Boshoff?
Thank you, Chairperson, and good morning, everybody. I hereby move for the adoption of the minutes. Thank you, Chair. I'm sorry, of the agenda of this meeting. It's a very, very important agenda.
Thank you, Honorable.
Thank you very much, Morning Chair. I second the proposal by Honourable Farmer, and Honourable Farmer, we'll leave the floor for you today, seeing it's your issue.
Thank you, honorable members. The agenda is adopted. Do we have any apologies so that we proceed, or also we adopt?
Chairperson's apology. That's it.
We only have the apology for the chairperson. Can we then adopt it and accept so that on record? Honorable Dlamini?
I accept the apology from the chair.
Any seconder? Honorable Farmer?
Second, Chairperson.
the apology for the chair is adopted and seconded. Can we then move to the presentation by the small-scale fisheries out? Okay. I'll first give Mr. Bauer 2 minutes and then hand over to you.
Thank you, Chairperson. Mr. Eoster, the presentations, I'll just give members a run. The presentations, Mr. Eoster will give us a brief introduction as to the expertise before us on the small-scale fisheries. They will then do a presentation, and thereafter Mr. Eoster will do a presentation, and thereafter the members will then interact for the question and answer session. Can I hand over to Mr. Eoster now?
Yes.
Thank you, Chair. Thank you, Mr. Bauer. Yes, I do not want to take up too much time. I will let our guests take the floor as fast as I can, but I felt I need to contextualize how fortunate we are to have this discussion. During our strategic planning, the committee resolved to review the legislation that is responsible for the challenges that the committee has been briefed on by the Saldanha community in terms of the small-scale fishers. But it is a complex set of legislation plus policy plus regulation that is creating a major challenge with different nuances as you move from north of the Northern Cape around the south coast into the Eastern Cape and KZN. And although the Saldanha Bay community had triggered the review, the committee's review would have to consider a broader challenge than what has been exposed to the committee thus far. And I felt that it is invaluable that the committee is assisted in understanding the run-up to where the policy was supposed to go versus where the policy is now, by being briefed by the group of people in front of you that was very closely responsible for the development of the amended legislation together with the department and also with the development of the policy. So we have people able to interpret the policy and legislation because they were part of the drafting team, not a committee secretariat trying their best also to filter through what is being said and what it means. We actually have the opportunity to engage the people that were part of the development of the policy, which would assist in allowing the committee to understand where the policy was trying to go versus where the fishers find themselves today. And hopefully this will aid the review process. I will leave it there, hand the floor to the Legal Resources Centre. Wilmien, I'm sure you will introduce everybody that you would like to introduce, but the floor is yours. Thank you very much for coming through.
Thank you for that, because we are now going to start on the same par. We were just reminding us, otherwise it's our resolution as the committee. Thank you.
Thank you very much, Chair, and thank you to the committee. We're really delighted to be here and to share the struggles, really, of the small-scale fisheries sector. My name is Wilmien Wickham. I'm an attorney at the Legal Resources Centre. We're a public interest law firm. We've been representing the small-scale fishing communities since around 2002, and I'll talk a little bit more about what has happened in the last 20 years. My colleague Sadia Kawa is here with me, and then Masifundise Development Trust, we'll hand over to them for the real meat on the bones and of the boring law. Once I've gone through just an overview of legally what has happened in the last 20 years, and then I'll hand over to Carmen. So just to start, and let me just see whether I know how to work my, well, let's wait for my slow computer. But to start, I wanted to give the committee an idea of who the small-scale fisheries communities are. And as actually Mr. Jooste has said, we are talking about communities right around the entire South African coastline, in all the coastal provinces. So these are thousands and thousands of fishers and communities who have depended for generations for food, livelihood, for kind of cultural and social cohesion on access to the ocean. And now I'm just going to start talking because luckily I know what it says. And so before the Constitution, before democracy, these communities were never recognized as small-scale communities and with recognized access to resources. In fact, practically every single one of these small-scale fishing communities were forcibly removed once or even twice under apartheid, right? So it's not that that their rights had ever been recognized, quite the contrary. However, there was less regulation, in a sense, ironically, before the Constitution. And so these communities were all able to find a way to access the ocean, not to the extent that they were supposed to. Of course, that was all reserved for the commercial and recreational sectors, but they were able to access the ocean to survive and to really create a network of survival for their communities. An important aspect also to say is that prior to the Constitution, customary law was not recognized as a source of law in South Africa. Our constitution, well, there was no constitution, but certainly the legislature and the government of the day did not recognize customary or indigenous law as a source of law at all. It was completely marginalized. And I mention that because this is a critical aspect of the small-scale fisheries sector. Many of the small-scale fishing communities have actual customary or indigenous rights to the ocean. And so now our constitution recognizes that, and therefore the legislature and the executive must recognize and give proper access to these communities. Yes, I've said those three things. This is the pre-constitutional situation of these small-scale fishing communities. Now, the Constitution, of course, brought a transformation and brought at least the following rights to be recognized. First, the right to equality, which includes equitable access to resources, which includes the ocean, right? It brought this fundamental shift, which is a recognition of customary or indigenous rights and customary law as a source of law equal to statute law. And there was a famous case, the Gongose case, where specific to fishing rights, the Supreme Court of Appeal said, customary fishing rights must be recognized. It can be regulated, but you can't ignore them. You can't just pretend like they don't exist. Then the right to food, and of course, when it comes to children's rights to food, that's not even subject to progressive realization. Children have the immediate right to access food. Right to freedom of trade, to choose what trade one wants to do. And as a whole, the Constitution brought with it this transformative agenda, as we all know. Now, the Marine Living Resources Act of 1998. This was to give effect to the transformation of the fishing industry. Unfortunately, the way that transformation was envisioned was to keep this sector very much as is, so only 3 categories of fishers to be recognized: commercial, the big, large-scale industry; recreational, sports fishers; and then a category of subsistence, which was really just fishers who were only allowed to fish to eat, but not even sell at a local level. So that was very, very much only subsistence. And so the transformation was supposed to happen through transformation of the ownership of industry, not transformation in the sense of opening access to local communities. Another thing that happened shortly after 1998 is that a slew of marine protected areas were declared right around our coastline. And these marine protected areas, that was all done in 2000, and they were almost all of them in small scale areas. So areas where small scale communities were fishing. And the reason this happened probably is because the small scale communities were never properly recognized. So no one even realized that their traditional grounds were targeted. And so suddenly, with the stroke of a pen, many of these communities lost total access to their livelihood, or it became very difficult with arrests and such in these marine protected areas. Then I've talked about the transformation of ownership of the industry. And importantly, there was no attempt of restitution, right? So we have restitution of land rights, but the fishing rights, the ocean rights that were dispossessed of these communities, there was no mechanism for restitution. And so the small-scale fishing communities fell literally through the cracks. They were not commercial, as in large-scale, big boats, had all the kind of financing that was necessary to fish offshore. So they largely couldn't apply for commercial permits. They were not subsistence. Yes, they fish to feed themselves and their families and their communities, but they also sell. They sell locally and even to marketers, but at a much more local level. And so they also couldn't be subsistence, because then most of their livelihood would be unlawful. And of course, they were not supposed to be recreational, because that's sports fishers, but many of them ended up being forced to buy post office permits just to survive through these recreational permits. So this wholly untenable situation came to the attention of, in fact, the Human Rights Commission first, Masifundise, and then they approached the Legal Resources Center way back, who then went to the Equality Court and challenged the Marine Living Resources Act on behalf of the small-scale fishing communities and said, this piece of legislation is in fact discriminatory. It does not allow for small-scale communities to realize their right to food, their right to equitable access to the resource, their right to culture, because it is in so many instances an integral part of the culture of the communities. And the minister at the time, so this was, the matter went to court in 2004. In 2007, a settlement was reached, an order by agreement was taken, and the order said that the department had to create a small-scale fishery sector, had to ensure that the socio-economic rights of the sector is realized, and that there would be equitable access to the ocean. So that is what the order said. It was envisioned at the time that it'll only take a year or so. Of course, it took many years. There was a very, very good process where a small-scale fisheries policy was developed, very inclusive, and that policy was then adopted in 2012. So finally, there was recognition of the small-scale fisheries sector. Now, the key principles of this policy and of this sector, these I want to highlight because they are really important. So the first really important principle was that the communities fought for a community-based right. So they said, different to commercial fishers and even recreational subsistence at the time, it's a community of fishers. Yes, we go to sea individually also, but the women in the community, they flag the snook. Other people in the community, they fix the nets. They're all part of an economy of a small-scale community. And so if you're only going to give individual permits to individuals, that takes away the livelihood of the community, which is something that's always been integral. What's also important was the community said, we know the ocean, and so we know how to regulate access between us. And so if you give it to us one by one, then we don't have a means of regulating in the community who goes to sea when. And so this was recognized as that the right would be community-based. There would be preferential access for the small-scale sector. This is very important. So, you know, the department would ensure that the small-scale sector has sufficient access. And I should say that South Africa is actually an outlier on the continent, because in most of Africa, in African countries on the coast, there are exclusive zones for small-scale communities. Inshore, and those zones are then for the exclusive access and use of small-scale fishers. And so preferential access, it was the idea that, you know, you have zones for small-scale fishers where you ensure that they have access to the resources that they require to be viable, right? Then another very important principle was this idea of a basket of species. So with commercial fishers, a commercial fisher applies for one species at a time. And so you get a permit just for rock lobster, or you get a permit for lionfish. But small-scale communities, they fish a variety of species because they fish all year, and they need to fish for whatever is available at whatever time of the year. And so the idea was that they were not going to be awarded one a species at a time, but a basket of species, and the department was going to look at the different areas, at the needs of the different communities, and award them a basket with different species in there, so that they could, again, as a community, regulate how to make that viable. And finally, the principle of co-management. And again, this was the idea that the community at the local level understands the resource and how to regulate it much better than people sitting in Pretoria, and therefore they will play a very significant role in how the resource is managed at a local level. This is also in line with international practice. So this was the policy. Now the legislation, the Marine Living Resources Act, had to be amended so that the Act allowed the minister to implement the policy. So, of course, at the time, this was 2014, we told the department to properly implement this new small-scale sector, you're going to have to make quite dramatic changes, because this sector operates completely differently to commercial and recreational, where you have a system of individuals applying for individual species, and they're individually allocated for long-term rights, etc. The department acknowledged it at the time, but they were in a hurry to get an amendment through. And so the idea was, let's just put in minimal amendment to the Act, and then we'll do a proper full review as soon as we're able to kick off this sector. Unfortunately, the minimal review is still what we have today. There was never a proper full review of the Marine Living Resources Act. And we will see that the implication of that is that the sector has remained a little bit of an add-on. So you have, you have the mainstream commercials. The recreationals, I can tell you, they are pretty much left to their own devices, completely unregulated, and there's an enormous recreational sector in South Africa. Regulation and allocation focused on the commercial sector, business as usual, and then whatever is left over, the crumbs, are going to the small-scale sector. This was never the intention, and so this is a critical issue that needs to be addressed. Then, in terms of the legislation, regulations were promulgated, and unfortunately, these regulations really were not consistent with the policy. So the regulations really just tried to tack on the small-scale sector to the commercial and recreational allocations. So, for example, it now says fishers must choose between commercial species and own-use species, and if you have a species for own use, it means you can eat it, but you can't sell it. If it's for commercial use, you can sell it, but you're not allowed to eat it, not even if you can't sell the fish. You're not allowed to eat it. This is not how things operate in these small-scale communities. It's completely out of sync with the reality on the ground, and it has really been to the detriment of these communities. And then what's really important is that even in the legislation, the minister was enjoined to create small-scale fishing areas in consultation with these communities. That has never happened. That has not happened, and the basket of species has also not happened. So finally, we've seen the problems in the Act, then the regulations made it worse, and unfortunately even the implementation has made it even worse. And so as I say, the small-scale fishing areas and basket of species, that was never done. There's no co-management anywhere implemented. The recognition of customary or indigenous rights, there's only been lip service to it. It's never been implemented properly. There are thousands of customary fishers who are still not recognized. And there was really no paradigm shift, like the way you had to create a new mechanism for small-scale fishers, and as a result, they are literally left with the crumbs of what is left over by the commercial sector and the recreationals. And we are so grateful for the opportunity to bring this issue to your attention, because it is really significant. I'm going to hand over to my colleagues at Masifundise now. Thank you.
Good morning. Good morning, Chair. Good morning to all the present. My name is Carmen Mandarino. I am the Program Manager and Acting Co-Director at Masifundise. As Wilmin was sharing...
Chairperson, can she repeat that name, please? She said it very fast.
Oh, sorry. It's Carmen Mandarino. I'm the Program Manager and Co-Director at Masifundise. I will try to speak slower. Just to say, we, as Masifundise, we worked in fishing communities for the past 20 years, working mostly with rural fishing communities along the coastline in the 4 coastal provinces. And as Masifundise, we have been consistently part of the process around advocating for the recognition of small-scale fishers. And so we are grateful that the committee is willing to hear about what is happening in the sector. And while Wilmin did present very clearly what is the legal state of things, I think that what is important to really emphasize is how this fight for recognition that small-scale fishers took through the courts and then participating in the development of a small-scale fishery policy was really about being recognized for what they are. So not necessarily wanting to become industrial, commercial, large-scale fishing operation, but also not being put in a situation where you can only fish to put food on the table and you cannot sell. And that was the purpose of the policy in its essence, really. And so, you know, to be 20 years down the line and finding ourselves in a situation where that very purpose of the policy has been lost in terms of both the development of the regulation and then in the implementation, it's creating a lot of challenges in the sector and in the lives of fishing communities, which are finding themselves in a situation where, you know, we hear some of the fishers saying, it was better before, which should never be the case, right? That people feel that it was better when they were actually not properly recognized. And I think that part of what is important to emphasize here is that in the way the policy was developed at the stage where fishers were involved was really done in a way that was trying to account for the diversity of our fishing communities, because a fishing community in the Northern Cape, in Port Nolot, doesn't look like a fishing community in Nibela, in the KZN. And so that level of openness and flexibility that the policy was trying to provide so that fishers and their community could self-determine both in the way they organize themselves in terms of the community based rights, both in terms of what they decide to fish, and now that was completely lost in the regulations as they were drafted and in the implementation. So we are now sitting in a situation where the spectrum of fishing activities as envisaged from the policies is not really being considered. Fishers really only have an option to be part of fishing cooperatives, which were formed according to the Cooperative Act to a certain extent, but even that is not completely clear. But now, so basically, just to give you an example, we have situations where hundreds of fishers, that's the case in Doringbai, for example, were clustered into one fishing cooperative. They were given 2 days training, which the department presented sort of the key aspect of operating as a cooperative, and that's all. And then they were left to operate themselves in a situation where, as you can imagine, managing a cooperative of 100+ members, it's really, really difficult, especially considering all the bureaucratic hurdles that exist with the cooperative system as we know it. For example, even a registration phase, one of the challenges that was faced, that every single fisher needed to have a phone number and a residential address that was unique, just for the registration. You can imagine the kind of hurdles people faced. So, for example, also the other issues with the cooperative is the fact that the structure of the cooperative, the constitution of the cooperative was provided to the fishers as something that they needed to adopt, and the only changes they could make was in the bylaws. So again, imagine now being a fishing community in the Dwesat-Quebe region where the customary rights have been recognized, but you are not even able to operate as per your customary rights and system. You now need to adopt this very bureaucratic cooperative system. On the issue of permits, I think this is very important for us to engage on, because indeed part of what the policy was trying to do was to recognize that, you know, we cannot box fishing communities either in just fishing for food or selling at a large scale operation. And so the small scale fishery, even as a definition, was supposed to really address that missing middle. Now, though, we are in a situation where as a fishing cooperative, you only have an option to either apply for an on-consumption permit, which doesn't allow you to sell, doesn't allow you to fish in marine protected area. Now let's think about the KZN region where most of the coastline is a marine protected area. Where are you supposed to fish? We don't know. But then also, if you do apply for a commercial permit, it's only boat-based, and you need to present a whole series of requirements around the surveying of your boat, the satellite system, having the proper boats to go out and fish. And this is not accessible to, I would say, at least 95% of the 150 fishing communities that were recognized under this process. So what this is creating is a situation where there is a few communities, a few cooperatives that have managed to strike some deals with commercial fishing entities to catch their quotas, and many of the fishing communities are actually not cooperatives are not operating at all. They do have access to their fishing on-consumption permit, but they are heavily criminalized even if they try to use those permits to sell some fish and to be able, you know, to make some money. And indeed, this is the situation that we find ourselves in. Finally, I mean, without wanting to take too much time, I think that the other issue that we see is that there has been no co-management whatsoever. The policy spoke about having different steps in which the voices of communities should be engaged in terms of defining, for example, the fishing areas, the basket of species, and indeed shaping the sector in that sense. None of that has happened. It's only in 2022 that, 2023 in fact, that the department started one pilot site for co-management in Port St. John, and even that is not really taking into consideration the voices of fishers, since it was formed through an environmental NGO. So, I mean, in this sense, it's also important to know that the department is kind of devolving their duty of co-management to a third party. And what this is resulting in a sector that has been completely even further marginalized, even further criminalized in the activities. And indeed, in all of this, there is no recognition of the role of women in the sector. There is no recognition and pathways for the youth to become engaged in the sector. And overall, I think that what this is creating is a situation where fishing communities are really desperate. They are desperate for support. They are desperate for a process that looks at reviewing what was meant to be in terms of the policy versus where we are now, and really find solutions that make the sector viable, as fishers are worried that the sector is going to disappear if there is no action. So I'm just going to stop here for now, and we welcome any questions. Thanks.
Take too much time away from the engagement process. I just want to see if I can get this to work. I prepared and circulated a presentation that did not know what the guests would present. So I'll shoot through a lot of what is duplication and background where needed. I definitely don't want to repeat things that have been said already. In the introduction, I already reminded the committee as to why the committee is focusing on this matter. It has been a resolution of the committee in the strategic planning to engage with the legislation as part of its review process, reinforced by the interactions that the committee has had with the Saldanha Bay community, but also recognizing that it's not just the Saldanha Bay community and it's not just the type of challenges that they have expressed. What's important here as well is, I hope this is large enough. I haven't got my glasses on, so I can't actually read the screen, but I'm hoping it's large enough. I can read the screen. If we look at the NCOP's publications over the last couple of years in terms of how it would like committees to proceed on legislation impact assessments. So it is not a tool that this committee is developing for the sake of this process. It is actually a tool that had been proposed by the NCOP during our strategic planning, and I have modified it ever so slightly to work better in this situation. But what we have started is the process in the dotted lines, where there has been issues identified by the committee. It is a Section 76 Act and a policy and a regulation that followed the Act. There has been initial focused public engagement, not nearly enough, and it's not nearly done, but it is a process that has started. There has not yet been follow-up visits, and there has not yet been broader public submissions on the matter. So we are in that dotted line box. But the end product, based on both this model and the initial model from the NCOP, would be the opportunity to create a committee bill, which is something that obviously will take a significant amount of consultation to ensure that the bill is fulfilling the needs of the people that it is being developed for. So this is the process that the committee has engaged upon, and we are at this step now where the final process of engagement and development of a committee bill have to start being planned and discussed with the NCOP. It's not something that the committee secretariat wishes to run in a bubble. This is something that needs the endorsement of the entire system within Parliament to succeed. But it is something that is going to be the end result of this process. Now, this has pretty much been dealt with. I do not want to stand still on any of these issues. Apart maybe from commenting, I think our guests are careful to step on the toes of the department. I'm less polite. There was a very long period of time since the Constitutional Court settlement and since the first policy was developed for the department to realize that they are not trying to slot a new category of semi-commercial or semi-recreational user into a licensing system for the amount of fish that's available. The opportunity that was missed was that the department fully subscribed its commercial allocations while it knew that it shouldn't. I'll say it as simple as that. They knew better. There was a policy developed. There was numerous appeals against the Equality Court settlement that failed. Therefore, instead of stepping back and saying, how do we handle this? What had eventually happened was the recreational sector remained unchanged, and the entire country's commercial catch was dished out on a number of rights allocation steps that the department took. So what we have now, and I pointed this out, I made an enemy of a member 12 years ago, and I don't know if Honourable Prince, if she still remembers that. She's not in Parliament anymore. But when we just started engaging on the small-scale sector, she had a discussion with me. She asked me what I thought of it. I said, we've got a massive problem. There is no space for these fishers in what the department has created in terms of the licensing and the recreational system. She interpreted it as me saying that there isn't space for these people, they must go away. What I was trying to say is, from a regulatory perspective, you now have to march people back in terms of what they have. It wasn't a case of you could open up a sector to a group that was told they're not allowed to be there. And this is the difficult part of the review that the committee is going to go through. For the sector for the small-scale fishery sector to enjoy the recognition that the Constitution says that they should have, somebody somewhere has to be walked back from a right that the department allocated to them after the policy was generated. We're not fighting about what the department did before. This is an issue of what the department has done afterwards. And it also creates challenges for us when for the committee, when you are trying to engage a community and the department follows up with its current program of Fishing for Freedom. A week or so after you were there, they go to the same community and they talk about how they are boxing the sector now. So there is still the narrative coming from the department of where they're taking this versus the narrative that the committee has to consider versus where was it supposed to go. And that is going to be two different places. It is an uncomfortable situation, but it is two different places. The perception of where it is heading now versus the understanding of where it should have gone if everything was done according to the policy and the judgments. So what I wanted to highlight here on this slide was already mentioned. So what the MLRA did recognize was mentioned, and this is the bit that I had stood on now, still now for a bit. Instead of leaving a chunk of the pie chart open, the pie chart was filled up with the three categories that they believed was going to be the type of categories, which is your subsistence or your recreational or your commercial. And one of the things that we find challenging as a secretariat when we did the background research on it is there's almost no economic viability studies that we can find on how, if the department wants to continue down this path, how did they generate the allocations? The committee has asked for some of this in official writing to the department. To date, we have struggled to find any way as a secretariat, of providing the committee with any evidence that the small-scale fishery sector, as the department had created, is viable. So that is one of the key things that also needs to be considered. So what I've provided the committee with as well is a written document outlining in a bit greater detail what it is that the Secretariat proposes. As it stands now, that is not a committee document that's going to be circulated. It is first circulated within the committee for consensus on the contents and for further input. But that document basically outlines the main motivation that will be put to the NCOP as to the reasons that the committee wishes to identify as the reasons for a review, because once we as a committee start publicizing what it is that the committee is interested in reviewing, it will attract attention. So I believe that the document that was circulated needs to be as sound and as well argued as possible before it goes to the NCOP, because that will form the backbone of the work of the review. The main reason for the motivation, I've started putting a few of the points down, is the department's use or lack of use of creating a space for the small-scale fishers in the way that the rest of Africa and the world recognizes a small-scale fisher. There's been a diversion from the policy document that was approved, and I also want to stand still on that. The department had published a policy, a gazetted final policy, and very little of what is the motivation for the review differs from what's in the policy. There's a lack of implementation of the policy, not a request of a group to review the policy and to change it completely. There's a lack of implementation of official policy. So there is already a court judgment and a settlement and a piece of legislation and an official policy in place. Those things technically doesn't have to be revised by the committee unless something comes up that requires to be strengthened in a policy document or in an act. But a lot of the building blocks is already there. It's just not being used. So the second point there was highlighted as well, the process of cooperative registration versus allowing the sector to operate according to its way, customary law and the recognized traditional approach to fisheries that the small-scale fishers have. The third point that is highlighted was also highlighted by our guest, and that is the paradigm shift that the policy was thought to have invoked in fisheries management versus what we are seeing now. The department knew what it meant when it wrote the policy, because if you study some of their documents, it's very clear that they were initiating some of the directional changes that was needed. So the fact that those came to an abrupt end is also a motivation for the review. So to summarize, a before and after snapshot of the rest of the fisheries sector shows no change in terms of what was done before the small-scale fisheries policy and what was done after the small-scale fisheries policy. Very, very little has changed, apart from a so far undetermined amount of allocation in terms of effort and total catch that were made to the small-scale sector. The committee has asked for the documentation in terms of what is the total allocation and total value of the allocation. The committee doesn't have it yet. So the nearshore fishery resource allocations, the potential changes in how the nearshore was supposed to be managed or could have been managed in terms of the policy versus what has happened, is one of the motivations for review. There has been no change in terms of how the sector is managed. So Again, I apologize if I'm talking from a secretariat perspective. It's atypical, but because the secretariat is putting a document in front of the committee for consideration, I'm emphasizing the fact that this is coming from the secretariat only, so that if there's any reviews or any questions, it is still going to be refined. But the secretariat is confident that the information that is required for a successful review process to initiate that process is available to the committee. I want to emphasize that, and I'm not trying to be funny when I use the word fishing for a reason, but the committee secretariat doesn't feel as if there's a fishing expedition for enough information. Everything is there. The secretariat is happy with what they have seen. And I've summarized in that document, that motivation that was circulated with the committee, a document that outlines that view for the committee to consider, because the secretariat doesn't speak on behalf of the committee. Should the committee review, edit, amend, but eventually adopt this document, it would be taken to the NCOP, and the discussion would start stating that the committee had envisaged a legislative review in its strategic plan, and it's at the point now that it needs to start planning it. That does not end the engagement with the Saldanha Bay fisher community. The committee has been challenged with finding time to get back to the committee, and the department has done a couple of things in the interim that has also made it a little bit tricky to go back, because certain things that the committee had resolved to do is now a little bit tricky, or would have to be reconsidered in terms of the types of engagement that the committee wanted to have with the community, with the department present. But so the process of providing feedback to that fisher community with the grievances laid still needs to be undertaken. But I am confident, I need to engage with the entire committee before I can state it that the committee is confident, but I am confident that should the review process be initiated, and should this be communicated with the community, and should their inputs from that point forward be considered on a regular basis, I think that the committee is starting to address many of the concerns raised in a concrete manner, and I do not feel that the committee needs to feel embarrassed about taking a little bit of time to get back to them, considering what it is potentially that the committee is able to communicate to them in terms of committee plans and hopefully the review of the policy and the legislation. Obviously, I think what also needs to be highlighted is that we are engaging a department that has inherited a process. The DFFE did not start the entire process. It was a DAF-initiated process many years ago, and there is a definite need, obviously, to continue engaging the DFFE regard to finding an opportunity for a joint return to the committee, to the community, barring that a return without the department is urgently needed as well in terms of report back on what the committee is planning. What also has to be highlighted, and this is why engagement with the department is very necessary, is there has been mention by the department of a review of the MLRA from their perspective as well. And it would be very unfortunate if a very useful process of review is undermined by the fact that two sides of a coin is being reviewed at the same time and being considered at the same time and having public engagement at the same time. There's a need for the committee and the department to also get into some form of understanding about what it is that the department wishes to review versus what it is that the committee wishes to review, with the knowledge that the committee doesn't have to have the department's blessing to do any of the reviews. It would just be bizarre if there's a dual public engagement process at the same time on the same act with different content. it would be bizarre, and I don't think the public would appreciate that. So there is a need to keep an eye on that process. In terms of the committee schedule, just to end off the last point, I think there is an urgent need for this process to initiate. From a secretariat perspective, I think the comment that I would like to say is that there's enough to start the process, because it's going to be a long process. But I cannot be prescriptive to the committee. So the document is before the committee, not for adoption today, but for consideration and for, I would propose before, because the third term hardly exists, there's one meeting in the third term. But if the fourth term can be considered the term in which, should the committee so desire, the process is discussed with the NCOP, and at least in broad terms, the review process is plotted out, then I think the committee is moving forward at the right pace. From that point forward, it will be a significant public engagement process that I do not wish to put timelines onto. But from the administrative timelines within the committee, I would propose that there's nothing holding the committee back, considering the information that's available to it, to make up its mind about the contents of the review in the fourth term. That's where I want to park my side of the discussion inputs, and then again, I follow the instructions of the committee. I haven't given the committee an instruction, I have given a proposed timeline. And Chair, I return the floor back to you for continued discussion on today's interactions. Thank you, Chair. Thanks for the opportunity.
Thank you so much for the presentations. I should think the three presentations that have been made are taking us a bit further from what we know. We have visited the small-scale fisheries in Saldanha Bay. We've got our report we discussed as the committee. We now getting the inputs from Masifundi's fisheries from the legal side, and they all show us the extent of the problem that we need to solve for the small-scale fisheries. And I'm happy that your presentations, the three of you, takes us to a point, and therefore I'll give out to the members to interact with the presentations. I'll ask my questions at the end. Thank you. Can I have hands to note? Honorable Honorable, remind me your name. Pinar. Honorable Farmer. Yeah, those two hands.
Thank you, Chairperson. Sorry, I was actually supposed to give to Honourable Farmer this. He's been fighting for this issue for almost a year now, since the beginning. But if I may, Chairperson, through you, sitting here, and it's a very noble quest you guys are trying to achieve here, and I take my hat off to you. Obviously, clearly you're passionate about the subject and you've done a lot of work on it. Obviously, I need to sit here as a member of parliament representing all people. Now, I've got one comment and two questions, and my comment will lead me into my question. I hope you can assist me. I know already there's a shortage, obviously, clearly, of fish, and like you described, the pie has been booked, and the pie is not currently big enough to feed these fishing communities. Now, the moment we start taking away from, let's say, the industrial, commercial fishermen, they will start knocking on our doors, and they're also going to be sitting here to give their side of the story. Now, that leads me to my first question. Instead of taking from one and giving to the other, is there possibility of expanding the pie by way of maybe focusing more on foreign vessels, you know, harvesting our local fish in our oceans. Is that something we can look at that can maybe alleviate or assist with regard to the availability of fish in our waters? Is that something we can look at? Is it still sustainable for them to feed themselves and sell and do all things? Is that still a viable option for us going forward, looking at the fish available in the oceans, the sizes of the communities? That's just something I would like assistance on. Thanks, guys, and thank you, Chairperson.
Thank you, Honorable Pinar. Honorable Farmer, your hand is up.
Thank you,
Honorable Farmer.
Chairperson. Maybe I should try and assist Honorable Pinar by saying that corporates, one need to look at beneficiation. On the one hand, you have the corporate big companies that in essence are making millions and millions out of the sector. And where those millions go to is lining the pockets of the rich, to put it in that manner. But at the same time, one does not want to be too critical upon that, because it's part of the economy and we want our economy to grow. We want our economy to do good. And you would never be able to remove profits out of an economy, then it's not an economy anymore. So I really try on this one, I really try to be as objective as I can, because I am firmly of the view that our fishing sector is on its way to a collapse if we do not intervene. And in the event of a collapse, it will do incredible harm, not only to the environment, but also to our economy as a country. So I think the answer lies within working together as a country in getting to an answer or a solution that can really be seen as a win-win for everyone. And I mean from corporate right down to the poor on the fishing markets. So I think, Chairperson, from the starting point, we need to tell Kobus to continue and go ahead as a committee. This issue needs to be resolved. We cannot lose the sector. We cannot have this sector collapsing. It's too big. It feeds too many people, and there are too many jobs dependent on the sector. So we cannot have it to collapse. But if we don't force, I'm using the word force, but if we don't force the department to see that they need to take better care of the small-scale fishers in order for the stocks in the sea to survive, because you're forcing fishermen to sea to poach, because they are going to survive, even if it means by illegal manner. They are going to survive, and that means that not giving them a sustainable livelihood from the sea, you are creating them. You are turning them into poachers, because there's no way a fisherman will sit next to the sea and starve, or see his children starve. He will go and poach. But poaching is killing our resource. And we need to work against it. I'm firmly of the view that to eradicate poaching, we need to allow the fishermen to be able to feed themselves and their children and give their children a good future out of the resource of the sea. So my questions in this regard, first and foremost, Kobus, I totally agree with your presentation, and I think we must push ahead. And if the department, unfortunately, is not seeing that we need to intervene urgently for this sector to survive, then we must make them see somehow. I want to ask from the Legal Resource Center as well as Masifundisi. This thing created by the department, wrongfully so, that we now try to correct in the way that the small-scale fishing sector is being dealt with, or is created. It has been running for a couple of years now in communities, and they've been operating on this thing for some time now. So in my view, I think the practice out there has shown us that even what we've envisaged, what it brought about, and how it's working in practice, and whether it's succeeding or not. I want to get at the basket situation with the area to catch. For instance, you cannot give Lambert's Bay a basket including abalone. Lambert's Bay doesn't have abalone. And then you tell that fishers they can only fish there. They will never be able to catch the abalone in their basket because there is no abalone in Lambert's Bay, for instance. So the basket situation that I can see was seen as probably a good thing might now, with hindsight, not actually be working as it was intended to. Maybe so. I think maybe the way we've envisaged the solution to be might also be reviewed in a way. I think the small-scale fishing or fisheries sector should be properly defined. I'm not sure it is properly defined simply because of what I just said, but also fishermen. I don't know if I can agree with you that you say, when you say, but they don't want to be commercial. I think there is a sense of want to be commercial, even though they don't have the necessary capacity to be commercial, but they want to operate in the same way of being able to make money, to elevate themselves out of a poor classification. So another question I have was, after the settlement order was agreed upon and the order was made, it doesn't seem as if the Act was ever amended to accommodate the order of court. If you can maybe explain that a bit more. But the small scale, in my view, the small scale fishing sector as created by the department is a total nightmare. It doesn't work. I am firmly of the view it impoverishes our people even further. And the other reason, Chair, I think we should intervene is, I had this discussion with the minister, the current minister, and I have somewhat reserved on being too critical on the minister himself, because he's relatively new, and a lot of these issues doesn't only arrive now that he's there. It's old issues, so one doesn't want to be too critical on him. But I did tell him, the minister himself, in our meeting on the boat the other night, he's very big on environment. But when we asked him something about fishing, or let me say you what I asked him. I asked him, there was this co-op in my hometown where I'm coming from, which is Lambert's Bay, is the cooperative there did eventually get their permit, but it was 2 days before the season closes. So they couldn't do anything really with it. And the question was to the minister whether the time to catch can be extended to allow them to catch. And this is the problem, if I can put it in brackets, I have with the minister, is that he does not know enough about the fishing sector. So he had to go to the officials in the department to give him some information of what's going on. And the department officials just said, but it's not possible. And he came back with an answer to me saying, but it's not possible. So for me, that's a challenge with regards to where the minister is at. He knows what to do when it's environment and that kind of thing, but his weakness in the three sectors within his department is fisheries. So that one will always be lacking, and he will then always be dependent on what the officials is saying to him. And for me, and for the fishermen out there, the officials in DFF in fishing is a problem. In fact, I also told this to the minister, that there's some serious allegation amongst the fishermen about fishery officials taking bribes or being corrupt in some way or the other. And I've asked them what's the possibility of lifestyle audits and that kind of thing for department officials. But I really, Pinar, for your sake, I really am not too critical on the minister. I don't want to be, because I know he's new. And I don't want to critique him on wrong things going in the department, but he's dependent on officials who are suspect. Let me just say that. So whatever he's led by from officials might end up being critiqued by fishermen. So, Chairperson, I, in essence, am very happy for this meeting. When I opened the information and the notice, I immediately started to speak to fishermen. And believe me, they are all awaiting a back report from me on this meeting for some good news at last. They are obviously not very happy with the time Parliament processes take, obviously, but they are in essence very happy with some things finally seems to be going their way through this process of this committee. Thank you, Chair.
Thank you very much, Chair, and good morning to everybody. I don't have any questions. I just have a comment to make. I think through you, Chair, we should initiate a meeting with the presenters here today and the department, because the majority of the questions that one wants to raise it applies to the department. And we cannot go forward if we don't get the right information from them. And I would also then suggest that the minister be present to be able to waylay what Honourable Farmer has just said, because it's bad to speak of someone and say ABC without that person being able to substantiate or stand up for him or herself. So if we could go forward on this, we do that. And then with regard to the committee bill, brilliant idea, Kobus, thank you very much. But as you said, it is for the committee to take forward now. You've done the initial work, and I think we must try and build on that. And with Honourable Farmer having all the background knowledge on SSFs, I think it would be wise for him to share everything with us that can be incorporated into your report that you've started. And thank you again to the presenters. I see the passion. And from my side, I also wish to see the small-scale fishers succeed, because it is a livelihood, and that's what we're about, creating jobs and a growing economy. Thank you very much.
I'll take these two hands, Honorable Mabilo, Honorable Sithole. Start, Honorable Mabilo.
It's me.
Yes.
Thank you, Chair.
Honorable Dlamini.
Chair, I must indicate that I have, in the beginning, informed the Chair I've got some challenges pertaining to hearing. I must still go to the doctor for checkup. But I must say, at least I have listened to the two presentations, including that of Mr. Kubo Joosten. From my side, I'm also coming from a fishing community, which is Northern Cape, Port Nolloth, 100 Club Bay, all the pies there is a fishing community. And I have reported in the past that we had a thriving fishing activity, including at the jetty. We had a fishing factory that employed thousands of jobs. In my other capacity as a former government employee, environment, I used to visit that factory, but it is closed. It's a debate for another time. I acknowledge the presentation by the experts in relation to the Marine Living Resource Act, and also, Honorable Chair, the purpose thereof in relation to giving effect to the equity court and so forth around the small fishing industry. My departure point, Chair, is in relation to the transformation itself, one, two, inclusivity within the fishing industry, and also broadening the economic opportunities, and also to ensure there's massive participation. In other words, communities living around coastal areas must benefit. Communities living around the parks must benefit. In other words, it's a paradigm shift in terms of changing the status quo, where the communities living around natural resources, their only means of survival is to sell their labor. That has to change so that they become active participants in their own growth and development in as far as economic opportunities is concerned. So I'll not be asking questions, I'll be broadly just commenting. And the whole question that we cannot run away from is the imbalances of the past that must be justifiably addressed, and is an ongoing matter. But safe to say, Chair, we must not lose sight of the fact that 25 years ago, the year 2000, this country hosted sustainable development. I hope colleagues will remember that in Johannesburg. The whole world ascended to Johannesburg. That time was still the Millennium Development Goals, the MDGs, that are 17. And we were a couple of years away from the implementation of the MDGs, which transformed into the SDGs, Sustainable Development Goals. We are 5 years away from that, the 2030 development goals. I will emphasize that what I raise in that context. To say one of the key issues, I hear my colleagues, they are correct that there's a threat in relation to the depletion of the natural resources. It's a real threat, and it affects livelihoods. But in the context of the SDGs, Sustainable Development, we've got to embrace sustainable fishing. in all aspects, in all facets of natural resources, that they must replenish themselves. So it goes as well with the question of climate change, which I think when we were in Durban during that oversight, we were exposed to the dangers of climate change, where because of weather patterns, there is the decay of fish, moving from where they are naturally are to outlets. But the threat of poaching remains a threat, especially when we don't have the necessary human resource in relation to safeguarding our own natural resources. So I agree with Farmer, as I indicated, that does constitute hope, and the intervention needs to be welcome. Our chair is to ensure that there is justice in relation to the fishing rights be given to the small fishers at a much faster rate. And also the support. There must be focus on support so that the key stakeholders as a small fishing communities, they are empowered. And also I like the notion of the community-based management that we must encourage so that they take charge of their own affairs. But I think there are certain elements that I want to recommend that they are strengthened. Is the whole question of monitoring and enforcement. That is key. The whole question of job creation, as indicated, the potential thereof, the value addition, community development, and the balance of the ecosystem. For me, Chair, that constitutes a significant progress, and I hope and trust that with the challenges that are presented, the gaps that are raised, weaknesses, the status quo cannot remain. It has to be pushed. When we go to our coastal communities for oversight, we will be able then to give them at least information that will encourage them. So I deeply welcome these interventions, the reviews, the presentation, but my view as a public rep is that it should not end up with us only. It must go to the recipients, those that matters most. Yes, we were in Saldanha last year as an oversight. There's a need, Chair, that we will recommend that we go as much as possible to the coastal areas to go and give them this kind of information and ensure that we strengthen the gaps. At least we take heart to the fact that we engaged the minister on the ship. And the minister was amenable to the concerns. However, there are gaps, there are deficiencies, there are weaknesses that needs to be strengthened. So at this point, I will not throw the baby with the bath of water to say this is step in the right direction. Our robust oversight role should be strengthened. It should not be only us who speak vociferously or eloquently because we come from the coastal areas. It should be for all the stakeholders, especially as I indicated. How far are we with the 17 SDGs in relation to sustainable fishing and so forth? So it requires of us to constantly monitor the developments so that as a country and as stakeholders, we contribute towards our obligations in relation to the Paris Agreement. It's not only a matter of the Minister of Transport or the Minister of Environment. It's a matter of all of us. Climate change is with us and is affecting our natural resources. Ours is to ensure that we sustain this for the coming generation. This generation of us is coming to an end, but there must still be life beyond this. And I think your contributions in this regard are valued. Thank you very much, Honorable Chair. I thought I must give a deeper input in relation to this matter, because this is a matter that is very close to my heart. Thank you very much. Thank you, Chair, for the opportunity.
Thank you a lot, Honorable Mabilo. Honorable Sitole.
Thank you very much, Chairperson, and my apology earlier on. I wanted to speak before Mr. Mabilo because I knew that I would be in this position right now. Because when he speaks, he makes sure that he closes all the ranks. Now, I'm in support of his statement and including Honorable Farmer's statement. Now, I just want to give my appreciation to the staff members that have compiled this report, that they have done a great job, and that finally we need to engage the affected individuals or organizations through the invitation to Parliament for feedback and progress, because at the end of the day, that's what we need to do. And then I also want to encourage members that are in our portfolio, like Honorable Mabilo have said, that this issue it hits straight at home, because from where he come from, he's also affected, and Honorable Farmer also. That during this constituency time that we are going to, or a period, the interaction with these people, it must be made, and so that when we do our oversight, we know very well where are the problems are. We are not only going to rely on the reports that we are going to get, but we are also going to rely on the honorable members that are coming from those areas. Because in an honest fact, Honorable Farmer spoke about something to do with jobs, especially for these fishermen or fisherwomen that are there. You see, we've got a high rate of unemployment in South Africa. Now, wherever a person is trying their level best to put food on the table, as the public reps, who must be in support of that person and give necessary advice where it's needed, so that whatever hassle that he or she is trying to do, it must not collapse, but it must also continue. It's a fact that we cannot all be lawyers, all be in parliament. Some people are supposed to be doing something there, but they need a support at the end of the day. Now, if fishing is something that it puts food on their table, it takes their children to school, for us is to support them. Thank you very much, Chair.
Thanks, Honorable Chairperson. Greetings to your good self, honorable members and colleagues. Chair, unlike Honorable Sitole, I'm happy to speak at the end, because I'll not talk a lot, because most of the speakers would have covered me. So it's nice to be at the end. Chair, I think we're really in support of the process to unfold. We really appreciate the work that has been done by all role players. Anything that speaks to including the previously disadvantaged communities, for me, it's a highlight, because we are talking about protecting the plight of our people. Therefore, the proposed document, for me, it's fine. And I believe it's a working document. We're still gonna have inputs along the way. We still have gonna have questions of clarity, ratification, and so forth. But any legislation, any regulation that will speak in addressing the challenges that are confronted by the previously disadvantaged communities, I will forever be in the favor. Therefore, I support that, let the approach, let the process an approach take place and move forward, Chair. We are delighted and impressed as a committee. Thank you, Chair.
Thank you so much, honorable members. I will first I'll just hand over to whoever to respond to the questions, because there were questions as much as they were comments. So I would like to give you first to respond to the questions, and then if there are still further discussions, we take that after your responses, of course. Thank you.
Thank you very much, Chair, and thank you to the honourable members. I'll start and then I'll hand over to my colleagues. Maybe to start with Honourable Pienaar, and say, you know, you may call this a noble cause, but it is in fact a constitutional imperative. It is legal. These are legal rights of the communities, recognized by the Constitution and in court cases. So you must find a way to realize these rights. It's not optional. And you know, the same kind of protection is not afforded to the industrial and certainly the recreational sector. I do maybe have good news though, and that is that on foreign vessels, it's a bit of a red herring. It's often raised as a big issue in our fishing regulation, which in fact it is not. But what independent scientists tell us is that the biggest issue is the recreational sector, not industry, but the recreational sector, which is almost entirely unregulated. I mean, it is extraordinary, the amount of fish that is taken out by sports fishers in South Africa without any regulation. So there's no, you know, the department doesn't even know how many recreational permits are issued all the time. And there's very little limit. So there's not the kinds of, the pie is in a sense not even, they're not even in the pie. They're outside of it, and it's very difficult to know. The department certainly can't know how many recreational permits are issued, and it is simply not regulated. So scientists, and they do a lot of work in the Eastern Cape on this, they say that is the biggest issue when it comes to sustainable fisheries in South Africa. And certainly if you want to create a viable small-scale sector, the recreational sector is where you will start when it comes to regulating. Now, that is important, and I think it's also important to note that, remember, the large-scale industry and small-scale that won't fish for the same species, and you know, it's near shore and offshore and so on. So it's also not always direct competition. Sometimes it is, but not all the time. Can small scale be sustainable? Well, so again, we can't possibly say that small scale can't be sustainable while we allow the recreational sector to fish in a fairly unregulated manner. And of course, internationally, we know that small scale is far more sustainable than large-scale industrial fishing. Then on the issue of the basket, and Honourable Farmer, I agree with everything you've said, really, and it's our experience. The one thing I want to note is this idea of the basket of species. So the idea, or what the law requires, is not for the same basket to go to all the fishers. The idea that what the law requires is that the department was supposed to ensure that every community has a basket of species that is appropriate to them, so that they won't have things in their basket that they can't fish. That just didn't happen at all. And so these baskets are completely arbitrary. And indeed, people end up with species in their basket that they can't fish because it's, you know, some done by a departmental official who doesn't know what's happening on the ground. So I completely agree, but I don't think the basket was the problem. It's how that's been implemented. But I do think that you are correct, that people have now for many, many years, first they were in the interim relief regime, which we haven't even touched on, and then the small scale, how it's now been implemented. And so, yes, I think there may well need to be a review of the solution. But I think we have an incredibly good starting point in the policy that was so well consulted. Then I also agree with you that there are many small scale fishers who will say, we would want to be commercial, or at least in some form. What one needs to acknowledge is that the small-scale fisher sector is got a massive spectrum of fishers. So in the Eastern Cape and KZN, people, you know, fishers fishing with a landline, handheld line off a rock is completely different to, for example, West Coast fishers. And so this sector was an attempt to deal with all of them. And so, yes, you will get a spectrum of what people's vision is for themselves in this sector. But all of that was, I think, carefully dealt with in the policy. It was just not implemented. Then I want to say that the example that you use about Lambert's Bay, it's happened in a number of communities that you get the permit after the season is closed or 2 days before, as you say. And this is part of the over-bureaucratization of the sector. So there are about 4 or 5 officials in the department dealing with the entire sector, and yet they are trying to micromanage every one of these thousands of communities. It's impossible. And so in a sense, we're calling for the deregulation of the sector, because the way it's overwhelming, the task that the department set for itself, and it's in any event not what the policy had envisioned. Also, just to say on, you know, allegations of corruption and so on, all I can say, and I think it is important to say, is that the rollout of the the rollout of identifying the fishers across the country, but in particular in the Western Cape, which was when Minister Creasy was minister, was so fraught that Minister Creasy herself went to court to review her own decision to allocate those permits. She said that it was so problematic that in fact she had to redo it. It was redone, unfortunately, only in the Western Cape, not the other provinces, because the problems were everywhere. It was redone, unfortunately, maybe only slightly less problematically, but the identifications of the fishers, of actual members of these co-ops are hugely problematic, and actual fishers in many areas are left out of these cooperatives. And then just one thing I wanted to mention, which we haven't mentioned, and this is a fact everywhere, but I think in particular in the Eastern Cape and KZN, it's a real problem. So we talk about these marine protected areas and nature reserves. We should remember that in many instances, these very fishing communities were forcibly removed to create those reserves. And now they're still reserves. In some instances, like Dwesa-Kwebe, there was restitution of the reserve, so it now belongs to the community, but they're not allowed to enter it. And when they do, or when they try and fish in what is their property, they get shot at by rangers. So we have clients in Isimangaliso, 2 brothers of the same family, a year apart, were shot and killed by rangers for fishing at St. Lucia. In Dwesa-Kwebe, a fisher was shot and paralyzed for life by a ranger. So we didn't mention these realities, but I think it's very important to mention it, because people are having to enter these areas, by fear of death. But it's what they will continue to do because it puts food on the table, and it is what they've always done. Thank you.
Yes, maybe just picking up on that in the sense that I think, thanks first of all, honorable members, it's great to hear that you are interested in continuing to take this forward. And indeed, I mean, I think it was Fabian that said, fishers will continue to fish. You cannot be put in front of the sea, and if you have to eat, you will. And I think that's also where what we have seen in terms of the implementation process, both in terms of the regulation and the actual implementation, has been a process that has been very much more about policing and limiting access for small-scale fishers than it has been about facilitating access. And I think this is the biggest grudge that communities have. They found themselves very invested more than 10 years from the court case to the actual initiation of the implementation in trying to participate in a process that was about giving them access, and they found themselves at the end in a process that is very much about restricting the access also in terms of the entire permit system, where imagine being a small-scale fisher, cooperative members leading that cooperative, and now finding yourself to have to apply for at least 5-6 different permits every year. Some of the permits requiring a longer sort of paper trail in terms of all the different kind of permits that you need to operate a boat, for example, and the cost that goes with that, from surveying the boats, from making sure that they are fit to be at sea. And then you apply and you don't hear anything for months, no feedback. Then you get feedback and you're told, oh, but something here, you didn't tick this box. And now you have to tick that box. Permits go back, takes another month, a few months, and you only get these permits back maybe a week before the fishing season closes or when the fishing season closes. And in the meantime, you also already engaged the department in asking, is it possible to look at an extension? And there is no response until such time where 6 months down the line, you're told, no, definitely you cannot get an extension because the season is closed. This is not going to work for the reproduction patterns of the fish species at subject, which was, by the way, the case of Port Nolot that we experienced this year. And so this is where I think also in terms of considering the small-scale fishery sector versus the other sectors, this is not really a competition in our view. It's about recognizing the existence of the sector, as Wilmin correctly pointed out. I mean, the law says that this sector needs to be recognized. And indeed, there is ways to ensure equitable approaches to the sector. So, for example, when it comes to commercial fishing rights, the fishing rights allocation process around the lionfish, which is a very important species for our sector, started in 2020. Eventually, it took some time, it was finalized in 2022. That process was happening while the small-scale fishery sector was already established. And the small-scale fishery sector over the years was promised 50% of that pie when it comes to traditional lionfish. We submit comments during the process, and we are told, you know, this is the fishing rights allocation process. It doesn't really deal with small scale. And even though we submit and we engage, it's only later when we receive the sort of notice of the allocation of the sector, the way we have to go on and do our own calculation to actually assess that more than 70% to 85%, depending on the area, of fishing rights for the traditional line fish are being allocated to the commercial sector, leaving the small-scale fishery sector with less than 15% of a key sector for their livelihood and survival, really. So that is also part of the issues. In a sense, the department has taken an approach that looks at managing these sectors independently from each other, but then at the same time saying to the small-scale fishery sector as kind of the last resort sector, this is all there is left. We cannot really take the rights away from commercial fishing companies. We cannot take the rights away from recreational, even though it's important that, again, we emphasize when it comes to the recreational sector, there isn't a similar approach that kind of looks at how many tons of fish we can dedicate to this sector. It's only based on the number of days that people can go out at sea. So by a mission of the department, they also now, as the post office services are collapsing, they're looking at introducing an online system for permitting. But as things stand now, they have no ways to assess how many recreational fishers are active and how much fish is taken out. And at the same time, they're restricting the sector that creates livelihood for so many people in our communities. I mean, we are talking about 22,000+ people recognized as part of the sector, but we know that there is many other thousands that haven't been recognized as bona fide fishers. There is no consideration on the impact on the value chain, especially involvement of women and youth. And this is just the very beginning of assessing how deep of a crisis we are facing when it comes to the communities. So yes, this is, I think, something that should be considered also in terms of how the baskets are designed for the small-scale fishers. I mean, the idea was really to sort of facilitate the very fact that indeed traditional fishers, customary fishers, artisanal fishers, you know, they take from the sea what the sea has to offer to them in their vicinity. They don't have boats that can go for 3 or 4 days of fishing trips. They will rely on what's in the near shore and the coastline. But so how can it be that what is immediately available to you is not part of your basket, and then you've been given, like for example, some communities on the West Coast, they were given sardines. Sardines cannot be found on the West Coast. They can only be found in the Indian Ocean. And so this is the kind of issues that we see taking place with all these, we are talking more than 120 communities on the ground. I also just wanted to really emphasize that indeed there is hunger in the sector for engagement. And I don't know if this is a proposal that is out of order, but I will make it anyway. We are having our national meeting with representatives of small-scale fishing communities from the community-based organization Costa Links. We will have more than 50 members there. The meeting will take place in Strand in the week of the 29th of September. So we will be very happy to invite the select committee or representatives thereof to participate and engage directly with fishers from all the 4 coastal provinces that can give you firsthand a sense of what their experience is, but also what they see as solutions. Because I think it's indeed, I think, again, Honorable Member, you're so correct in saying, I mean, it's 30 years of fighting this fight, and things have changed in communities. But this doesn't mean that they still don't have a sense of what, and a vision of what the solution can be to make this viable, because this is not just about an economic sector. It's not just about GDPs. It's about really the very fabric, social fabric of the communities on the coast. And it is about also a living heritage and a cultural heritage that if we lose, it's not going to come back. And therefore, I think that's also part of what needs to be considered. It's not just about the economic sense of it all, which there is a lot of, especially if we're looking at this in terms of sustainable development, but there is also an element of culture, tradition, and heritage that also mustn't be lost sight of. Thanks.
Something came up now. The lady opposite me, you spoke about, or was it you, about the fishing, the permits, and how long it takes. Is there a process in place where the small-scale fishers can appeal, or is there no appeal platform for them?
Well, yes. So in terms of the MLRA, any decision by the minister can go through an internal appeal. So yes, they can appeal. The appeals take an enormously long time, and in most instances, for example, so let me give an example. I mentioned when the small-scale fishers were recognized by the department in a couple of years ago. people then all appealed, those that were excluded. But even the appeal process was so problematic that the minister then took that whole process, including the appeals, to the High Court, to ask the High Court to allow the department to try again, which I think is important to mention. Thank you.
Noted, Honorable Farmer, but before that, I should think there's a question I didn't hear you responding to from Honorable Pinar. He was asking if we still have enough fish in our seas. But we'll respond to it when Honorable Farmer is finished.
Thank you, Chairperson. I would really love Masifundisi to submit a formal request for this committee or a representative of this committee to attend that function that you're planning, because one might want to attend, but in obviously in official capacity, if possible. Secondly, Chair, and maybe this will then be an attempt to answer Honorable Pinar's question, the pie that you were referring to earlier. In the fishing sector, they call it the TAC, total allowable catch. In Afrikaans is totale toelaatbare vangste, TTV. Now, the scientists determine for a TAC for each year or each season, which means they inform department that for this year you can catch X amount of a particular species. And then the fishing rights for that season is then adjusted based on that TAC, total allowable catch. Now, the point I wanted to make, which I missed earlier to make, is the pressure on the resource. When you have 10 big companies each having a 800-ton boat to catch with, and you have small-scale people each with a 3-ton or even less than a ton little boats, obviously the 800-ton boat is putting the most pressure on the resource and not the small-scale guy. I mean, it's like in plain logic to assess. So I don't think one can go towards the pressure on the resource being considered in allowing too much small scale, because they're not really putting the pressure on the resource. Chairperson, the other issue I also thought we need to be cognizant of further, and I love to say this, and I say this all the time, and people are probably getting bored of me saying this all the time, is my father was a fisherman. My mother was a factory worker for 39 years. And at the end of that 39 years, she walked away with 18,000 rand. Now, the amount of work or jobs being created by this industry, the amount of money generated by this industry really needs to be explained to us as a committee so that we know what we're dealing with in real figures and numbers. Because I'm pretty sure that this fishing industry of this country is $1 billion industry. And we as a committee needs to see and know, when we're dealing with these issues, where is the beneficiation really going to out of this industry? Just to inform us in deliberating and taking decisions on this matter. Thank you, Chair.
Kopas, let me give you first and then.
Yeah, thank you, Chair. My apologies for just maybe wanting to say something about the direction in which the conversation is going, but also maybe to highlight something about my background, which is, I think, useful in terms of this discussion. The discussion at the moment is revolving around a couple of very important things, but it's not necessarily all that is going to trigger the legislative review. When the Secretariat was trying to work out what the problems were, the focus is purely legal. It is purely a case of, if we want to make it that simple, right and wrong according to what the Constitution or the law or the policy is wanting. That is not inclusive of the economics or the sustainability of the sector, because the sector must be economically viable and sustainable regardless of who the players inside of it is. So this review is not about who gets what, but about what the Constitution had said and what the legislation says and what the policy says. But from a sustainability perspective, the first time I was refused access to fishery data was 1993 as a young student. I'm a marine ecologist by training. I've spent years in fisheries data. And South Africa has been pushing its fishing resources to the brink for decades. It is not that it is not important, but it is not something that is going to happen because the process of how the rights are allocated needs to be looked at. It is inside a context of decades of overuse that this is playing out. And I think that's important for the committee to note, because sustainability is a major concern, but it has always been as if fisheries management was in a little bit of a brinkmanship game for a very long time. And I think what's important to note about something like the lionfish sector, the lionfish sector is allocated to a commercial sector, and then the 500,000 plus recreational anglers can catch whatever they can catch. I was a lionfish observer for almost 2 years in Port Elizabeth. And the amount that the recreational sector can take compared to what is on the books as a commercial sector is significant. But that does not change what this review is about. This review is about, what did the Constitution say? What does the legislation say? What does the policy say? Within that debate, there will be a lot of players and a lot of issues. But we have tried very hard to keep those away as considerations for the review. It will come up in the review, but the consideration for the review is legalities and constitutions and policies. But inside of that, economics and sustainability will come forward. Thanks.
Thank you, Kopas, for reminding us about your background, really, because it is clear after we've met with the Saldanha Bay small-scale fisheries, we then resolved on the legislation governing the small-scale development and implementation of the small-scale fisheries. So I should think that's the area of focus, because as much as we talk about the things that affects them and whatever, but if we don't legislate towards change so that they are able to benefit, we are not doing anything. I should think really we should focus on the legislation, because that's where we'll have a way forward on the way in which, if you have heard the lady who's coming from the law firm, she is saying they've been representing these people for more than 20 years. So it is upon us as legislators to make a legislation that will change all these things that they are coming to us with. So I should think, I agree with Kopas in trying to bring us back to what actually we should be doing as the committee if we want to bring change to the manner in which these small-scale fisheries are being treated. Because there are policies, there's everything, but it is upon us to change everything for them. We are the people who changes whatever in the land, because we are the people who are making laws. We are the people who are changing legislation and do it according to the manner in which we want, so that it favors whoever has come to us. I'm talking also as one who have met with the small-scale fisheries in Saldanha Bay. If you could see the manner in which those people were desperate, and looking at us as the people who will give change to their situations. And we are really discussing here and there, but with what I should think I concur with Honorable Dlamini, because with what Cobus has presented to us, it gives us some way of then intervening as the committee, so that at the end of the day, we pass a legislation so that we are able to assist these small-scale farmers. But I am not closing the debate. If anyone still wants to say something, also I should think you have taken the point by Honorable Farmer that the invitation that you have said should come to the committee through our secretary in writing, so that the chairperson will be able to see what to do in order to have someone who is sent, or even the whole committee if things permit. Thank you. Honorable members, do you still have something to say on the presentations? Okay, thank you. If so, I should think we've come to the end of our deliberations with I don't know what to call them, but the presenters who came to us today. And I should think we are agreeing on the fact that we need to sit down as the committee and have a way of assisting the small-scale fisheries, as we are the people who are really to do that. And we thank you for your time. We thank you for your presentation, because to me, it means that really there are people who have been working with these small-scale fisheries for many years, trying to assist them. But now, with your input, we have empowered us also as to what we must do. I should think with those few words, let's release you so that we can finish the business of the committee. Thank you so much.
Thank you, Chair.
Chairperson, can I maybe just add, after closing, obviously, to the... Yeah, no, while they're getting ready to leave, to thank them on behalf of the fishing communities for the work that I know Masifundise has been a long time involved in our fishing industry and with our people. There's a guy in Lambert's Bay that worked for them, Nico Waldeck, and we know each other personally. So thank you guys, and also the lawyers for your help to our communities. It is really much appreciated. Thank you.
Thank you, and we remain available to support the committee. Thank you.
The next item was consideration and adoption of committee minutes. I think there are two sets of minutes. Is it like that?
Yes, I can't seem to open it.
Mr. Bauer? There are two sets of minutes that were sent, yeah, the 15th and the 22nd. Because they were sent to us, I should think we have read, would just adopt and second those who were present on that day. Honorable Boshoff,
very
followed by
much.
Honorable Mabilo.
Chair, the first set of minutes, are we doing both together? All right, I move for the adoption of both because yes, I was there. Thank you.
She has moved for the adoption of both sets. So I would want a seconder to those two.
No, thanks, Chair. I was part of that meeting. I second the proposal that we adopt the minutes.
They said both, they've read both.
No, you weren't part of the last. My laptop is not giving me the, can you just pull up the minutes, Ma, please? Because I need to see the agenda.
Aye, this is meeting documents, sorry.
The minutes. There's the 15th.
The virtual one. The 15th was the virtual meeting. Let us look for it.
15 was Boshoff and Mabilo, right, Mabilo?
Mabilo was
22nd
there.
And the 22nd.
The 22nd.
You know what's wrong with my laptop?
Let's wait for it.
Mabilo's apology.
Oh, so can someone who was there on the 22nd?
Chairperson, I never missed a meeting. I don't want to miss a meeting.
So,
I therefore would
second.
second for both amendments. Thank you, Chair.
Thank you so much, honorable members.
Can we just say to Kobus, thank you so much for all the work you've put in so far. We do appreciate it because to do the legalities behind a bill, I've tried it before, it is enormous work. So thank you.
Thank you, Honorable Boshoff, for that. Honorable Boshoff is the chairperson, so she knows things that we must not leave without saying in the meeting. Thank you so much, honorable members, for your time. I know others are debating just like me. We still need to prepare our speaking notes. We've been debating for so long, we are tired. Thank you so much, honorable members. The meeting is adjourned.